All right, Greg. So we're going to talk about the process that potential clients of our firm can expect when they reach out to us, whether it's by phone call, whether it's through the website, intaker, whatever. When they think they have a potential case and they contact our firm, take us through sort of what the next immediate step is.
Okay. All right. Yeah. So it really depends on how people reach out to us. First of all, if somebody reaches out to us by phone, they get a prompt on our messaging system or our phone system to dial one if they have a potential new medical malpractice case. And they are automatically directed to one of our two intake professionals. We have a nurse paralegal, Stephanie, and we also have Megan, who is another one of our intake professionals, though not a nurse. She's usually the first contact for people who call. If somebody reaches out to us through our website, there's a request for contact form they could fill out. That gets generated into an email that Megan, Stephanie, you, and I, and others at the firm all see. And whether that's the case or somebody goes through our chat room, intaker, the lawyers will always read it. The partners will always read that, and we'll lay first eyes on it. And if we feel like it's something that needs to be expedited, because it's perhaps a time sensitive or very serious matter, we will let Megan or Stephanie know that, okay, our intake team. So at that point, after our intake staff receives either the email, the chat, or the phone call, a true intake is scheduled, a formal interview with our nurse paralegal, which usually lasts anywhere from 30 minutes to 45 minutes. And during that interview, our nurse paralegal will go through the essential timeline that we need to learn in order to evaluate the case. And by what I mean by evaluate is to evaluate the different prongs of a medical malpractice case. Do you want to take it and explain a little bit more from there?
Yeah, absolutely. And I want to just touch on one, sort of earlier point that you raised is, when that initial inquiry comes in, sometimes you and I, just based on our, history of having done this kind of work for decades, can tell just on a fact pattern that the facts are not a case that we can investigate. And, in those circumstances, the prospective clients will be notified, either directly by call from one of our, intake professionals or via email that, these facts are not ones that, would rise to a level of a case that we could ever under any circumstances pursue. So when you are getting reached out to us and having an intake set up, that means that you or I have looked at those facts and determined that, at least on the face of them, that there's something worth investigating, from that point forward. And that is when, we have the intake professionals gather meticulously all of the information that we now need to give an even more in-depth assessment of, is this a case that could have merit that we could proceed upon? And when we're doing that, you and I are looking at essentially three prongs. Number one, is there a relatively clear-cut evidence of negligence? Is it pretty clear that something happened that shouldn't have happened? Whether that's a delay in diagnosing, it's mistreatment, it's improper discharge, it's a surgical mishap. So that's number one. Number two is then, if we do identify something that looks like it could be a violation of the medical standard of care, then we're saying, but did it cause any injuries? Because a lot of times we'll see cases where, unfortunately, the people that are contacting us have a, very bad medical condition. And the bad outcome is more the, complication of the medical condition and not an injury due specifically to either the act or omission of the medical provider or the hospital. And then number three, what we're looking at is, are the harms and losses of a significant magnitude that would justify undertaking a medical malpractice case. And, while this may sound a little crass to, consider dollars and cents, the reality is that we don't want to undertake a case, that winds up in the client getting little to no money, and it made no difference. And medical negligence cases are, very expensive, very time consuming, very taxing on us, but also in particular the people that we work for, the clients. And we don't want to put people through a case that's not going to likely resolve in a meaningful outcome. So I'll kick it back over to you, Greg. Let's, obviously, if you or I looks at that in-depth fact pattern, and again, we determined that it does not meet the criteria, it doesn't satisfy all three of those prongs we just talked about, then the client is going to get a call back with an explanation, and typically followed by a letter explaining, why and that we cannot take the case and when the statute of limitations is. But why don't you continue on with, when you or I looks at it and says, this is worth investigating. What are the next steps at that point?
Right. So that initial decision is really a critical and often difficult decision to make, whether to investigate a case just based on the initial intake. And since an investigation can take so much time and has a lot of costs associated with it, we have, I'll say, different degrees of investigation, right? So there may be a case where I'm a little bit on the fence about it after reading the intake. Perhaps the patient had a lot of underlying medical conditions which may have made that person more at risk for a bad outcome, from medical care, and we would have difficulty separating those underlying conditions and the harm caused from those from the harm caused by any medical errors. So in a case like that where I'm a little bit on the fence, I may say, let's get portal information, login information. So I could look at a few medical records. Just did this yesterday in an unfortunate case in a woman who lost her foot from extensive peripheral arterial disease and complications of the treatment of that disease, which is just basically plaque and buildup and diseased arteries in the leg. I opened the portal, I looked into the portal a little bit and read some of the doctor's notes, and it's amazing how much information you could gather about the critical events in question just from accessing the patient's portal. So that's one sort of expedited way of reviewing a case that you might be on the fence about. But in many, many other cases, we want to do a full and complete review that involves requesting all of the medical records relative to the event in question, which often means the complete chart for a hospital admission, doctor's office visits, maybe even rehabilitation visits. Of course, it all depends on the type of case. So that's the next step. And what we do is we actually reach out to our clients again and tell them that we want to obtain these medical records, and we have them sign authorizations and forms, cover letters that we'll use to send the authorizations to the hospital so that our clients can get the medical records. And usually we have the records sent to our client, although sometimes we use a service that helps to expedite this process and streamlines everything as well. We're actually just starting to do that, and we hope that we'll have some success with that. So after we get the medical records, which could take a while, and people are usually very patient about that, as they need to be, because it could take 4 to 6 weeks to get medical records. Regrettably, sometimes we need to keep going back to the healthcare providers, knocking on the door again. Did you receive the authorization? Did you receive the request? Resending the authorizations. That's just the unfortunate nature of this business of getting medical records and investigating a case. But once we have all the medical records, Brendan, what's next?
Well, before we go next, and that's an important next step, I want to address two issues that I think sometimes prospective clients wonder about. Okay, so number one, why are we putting so much stock into getting the medical records rather than just making a decision based on the facts that the client tells us? And, that is not any reflection on our belief in what the clients tell us. However, based on our experience, the medical record is the bedrock piece of evidence in any medical negligence case. I mean, it is the evidence. And oftentimes, sadly, things will happen, patients will experience things that never make it into the medical record. And that's terrible. But if it's not in the medical record, that is a significant factor in our analysis on whether we can prove the case. Because at the end of the day, we and the patient, it's our burden. So we've got to have the evidence there, and that evidence needs to be in the medical record. And, that'll dovetail into a second when I explain what we do with those medical records once we get them and we confirm that we think there is a case. But before I get there, one other thing that a lot of our, clients wonder about is, why are they not talking with one of us right off the bat? Or why are they not, coming into the office right off the bat to tell their story to us face to face? And, whether people agree with this, like this, don't like this, the reason we do that is so we can make the best decision for the case based on the evidence that we'll have to prove, during the litigation or during the trial even. And we are compassionate people. You and I are empathetic people. And when we meet people face to face and we hear their stories about, the horrible thing that happened to their family, that happened to them, it can cloud our decision making. And at the end of the day, we have a responsibility to make the best decision for the clients, for us, on whether this is a case that we believe that we can win, and win in a way that will make a difference. And that can be counterintuitive to people, but there is an absolute reason why our process in medical malpractice cases specifically is set up that way. And so now I'll answer the next step question that you posed to me, which is, you and I get those medical records and we do a deep dive into them. Number one, making sure that we have all the necessary and relevant medical records. But number two, you and I are bringing to bear our years of experience analyzing medical records, medical issues, the different types of medical malpractice cases that are out there, and forming our professional analysis and opinion on whether the medical records support those three prongs that we talked about a minute ago. Okay. And I think another point to bring out there is a lot of bad things happen to people, when they're in the medical realm. I mean, obviously, doctors, hospitals, nurses, they do a great deal of good and we all need them and depend on them. But a lot of bad things happen to people when they're in the medical system. A great majority of the bad things that happen are not because of medical negligence. And so because of that, I would wager to guess that 95% of the cases that we investigate, we ultimately decline before filing a lawsuit, because they just don't meet all of the specific criteria we need to feel that we can bring about a meaningful outcome. But I'll kick it back over to you. So after you and I, we make sure we have all the relevant medical records. We've scoured through them. We do our online research, looking at the literature. And sometimes based on our past experience, we just know when we see it in the medical records that this is a case that we can take and we can win. But does it stop there, Greg, just because we think the medical records support a clear-cut case?
No, no. So in Pennsylvania and many other states, but we primarily practice here in Pennsylvania, we are required under the laws governing medical malpractice cases to consult medical experts and have those medical experts review the medical records to determine whether the case has merit. And the selection of experts is case dependent, right? So, and actually, it's dictated by the law in Pennsylvania. Generally speaking, if we're suing a physician, we need to have a physician of the same specialty as the potential defendant physician. And that physician that we reach out to, the specialist, must review the medical records and form an opinion whether or not the defendant doctor, potential defendant doctor, deviated from an appropriate standard of care, and if so, whether the medical errors, the deviations from the standard of care, were the cause of the harm to the patient. So we have to create that bridge, and it's all really through the expert's eyes, their opinions, and the years of experience and knowledge that they bring to bear. And if an expert supports a case, then we file at the time of filing the case something called a certificate of merit. And it's a certificate stating that we have spoken with this expert, we've given the expert the opportunity to review all the facts of the case, which are, again, as you mentioned, are the medical records, and that expert has offered an opinion that there were deviations in the standard of care. And there may be multiple experts in a particular case who we need to consult. There's always one physician at least to comment on the standard of care. But that issue I mentioned of causation, making that bridge between the medical error or errors and the harm, may require us to consult with a different doctor, right? So to give you a perfect example, you have maybe a case involving the delay in diagnosis of prostate cancer. And perhaps a family physician did not review a high PSA score, even though the score was reported in the patient's medical chart, but they didn't review it. The physician did discuss that result with the patient and didn't recommend further testing. So we would need a family physician expert to review the records of the family physician in question and offer an opinion on the standard of care, but we would also need potentially a urologist and potentially an oncologist, almost surely an oncologist as well, to comment about the effect of the delay in diagnosis by the oversight of the PSA score, which is it's a blood test that identifies an early marker of prostate cancer. So that's sort of how it plays out. And one thing I will mention too, Brendan, that I thought of is that you mentioned how we can consider what our clients tell us about what happened, even facts that don't necessarily make it in the medical records, but we are really confined to those medical records when we're investigating the case. The same goes for our experts, and I tell folks this all the time. I can't tell our medical expert, look, this is what the client remembers happening, or this is what the client, the patient, told their doctor by text or on the phone. 9 times out of 10, our medical experts can't rely on that because that's not what they do in cases like this. They must confine their review of the case to the medical records. There are exceptions, right? There are some exceptions where in this day and age that we live in, there are communications between patients and doctors that are not always documented, but maybe there's a note in the chat section of a portal, right? Or maybe there's a kind of a footprint through phone calls and a phone log that shows the phone number of the doctor and the phone number of the patient, and we could prove the conversations were had. Those might be exceptions, but more often than not, the experts have to confine their review of the case to the medical records.
Yeah, exactly. And I think the one exception really only would be text messages where the healthcare provider is actually substantively responding. I think that is something that the experts could rely on, but generally they have to rely only on the medical records because that is what doctors rely on in continuity care, evaluation, peer review. It's the medical record. Now, one sort of last thing I want to mention here that again is oftentimes on potential clients' minds is, we are, as part of the investigation that we just described on this initial intake to determine if this is a case that we can help somebody with. We are investing a tremendous amount of time. Our paralegals are investing a lot of time. And if we get to the point of ordering medical records, that costs money. If we get to the point of retaining experts to review the medical records in the case for purposes of a certificate of merit, that costs a lot of money, many thousands of dollars. But if we consult with an expert or experts and they tell us definitively that it is not a case, the potential client does not owe us anything. That is a risk, a benefit that we offer as part of this firm is that we don't get paid a dime. We don't get repaid our costs, even if it was thousands of dollars we outlaid to investigate a case, if we don't end up taking the case. And only if we enter into a formal contingency fee representation agreement with a client will we potentially one day be entitled to be compensated for our work and reimbursement of our costs? And that's only if we make a recovery. So from a prospective client's perspective, there is no risk. And it kind of amazes me some days because of how we're all inundated with lawyer advertisements saying no fee unless we get a recovery for you. How many potential people are worried that we're going to send them a big bill or ask to get repaid for our costs, and we have to explain to them, no, that's on us. And the only way we would ever get this back is if we think we can help you and we make a recovery for you. So unless you think there's something else critical to talk about here, I think this is a good stopping point, and we can explain the representation agreement and how the contingency fee and reimbursement of costs works in another video. But I think that was a pretty good summary of what our potential clients can expect when they contact Lupetin and Unatin about a potential medical malpractice case.
Well, just maybe one more thing. How long does
Yeah.
it typically take, this whole process?
Yeah, that's a great question. From start to finish, again, typical lawyer answer, it depends. And that depends on how quickly we can get the medical authorization signed. Sometimes if it's a death case, we've got to get an estate opened. But if it's a non-death case, how fast can the client sign the authorization? And fortunately, we can send them an electronic authorization for them to e-sign, which speeds that process up. But we're also at the mercy of the healthcare providers to get the medical records, and that's if we can't get all the records we need through accessing their portal. But typically, we'll make requests for records, the providers, and they work with all of these intermediary groups to get the records and process the records and charge us for those records. And they typically have 30 days, but it can take longer than that because oftentimes they don't send us the right records, or the hospital is slow, or the doctor's office is slow in responding to them, or the request for medical records gets quote lost or misplaced, or they don't have a record of it and we have to resubmit it. And so through no delay or fault of our own, it oftentimes takes months until we're in a position to make a decision on whether it's a case that our firm can handle. So, and we try to explain that to people up front, that, it may be 2, 3, 4 months, from the time they first contact us until we're in a position to intelligently analyze the case, talk with experts, and make an official decision on whether we can move forward or not.
Yeah, that's the experience. It's one of the slowest, painstaking parts of the case, but it's also the most important part of the case, because our goal is to know at the end of our investigation that this is a case which we should win with a settlement or verdict, so that we're making the right decision for our firm, but more importantly, for our clients.
And I'll end as well by saying that, while we cannot help the vast majority of the people that reach out to us for one reason or another, the cases don't meet merit, they have a problem, there's just something about them that we cannot undertake to handle the case. What we try to provide in every single case that we investigate is peace of mind, that at least if we tell you that we can't handle the case, or this is not a case, that that prospective client knows with some degree of certainty that, hey, look, I looked into this, I had questions about it, but some professionals in this industry explained to me why it's not a case, so I can kind of put that on my mind and stop wondering. So that's how we do it at Lupetin Unatin. Thanks for watching, and we'll talk to you soon.